start us out a little bit and bring us back up to date on where we were after the last meeting. As many of you probably recall, we were not able to conduct the formal public hearing at the last meeting because we were unable to get notice delivered to all of the required taxing units, so that could not be a formal public hearing. We have now completed that task, so we can proceed with the formal public hearing. Before beginning that hearing, I thought I'd review some primary concerns that were raised at the last meeting and discuss some potential resolutions for those concerns. A great deal of concern was expressed about eminent domain. And we discussed at the last meeting that the Redevelopment Commission does not have the power of eminent domain. The statute that authorizes, it gives them their powers, specifically says they do not have the power of eminent domain. But in addition to that, I wanted to point out to you that the state of Indiana places pretty severe restrictions on the use of eminent domain where the person or entity exercising the power intends to transfer the property to a private owner. This is the kind of thing you hear about where a state or a municipality exercises eminent domain in order to help some developer with a project, gets the property from the landowner, turns that property over to the developer. Indiana restricts that substantially. And what they say is, in that case, you have to have a public use for the property. And they define public use to include, I want to read it, I don't want to paraphrase it. Possession, occupation, enjoyment of the property by the public or the public agency, leasing by a public agency for fundamental services, or as a public utility, energy utility, or pipeline company. That's a public use. The statute specifically excludes the public benefit of economic development, including an increase in tax base, tax revenues, employment, or general economic health from the definition of public use. So unless you're going to use it for one of those specific purposes I outlined first, you can't say we're going to condemn this or exercise eminent domain in order to get an economic benefit or increase the tax base. That's specifically excluded. Another concern that was raised was the inclusion in the plan of a section titled Special Development Considerations. That, I think that the commission tonight will have before it a modified resolution for its consideration that will specifically say, rather than may not exercise the power of eminent domain, it will say will not exercise the power of eminent domain. And it will also say that it will not acquire property in the economic development area, whether by eminent domain or otherwise. That's one potential amendment that the commission can consider tonight. Another concern that was raised was the inclusion in the plan of a section titled Special Development Considerations. That section referred to including EPA and IDEM, Indiana Department of Environmental Management regulations, and other regulations. Again, the commission could consider removing that section altogether. It is not necessary that it be there. Concerns were also expressed about the but-for requirement, and that's not just in the, all of these were raised in the remonstrances, which you have received also. But As previously discussed, but for capturing the revenue, which would be generated by this TIF, it'll be difficult for the county to fund improvements to roads, bridges, other public infrastructure, police and fire protection, and school funding. We have compiled a number of documents for the Commission's consideration that deal with these issues. The county engineer has told us that the county will be losing nearly $500,000 a year of community crossings money in the future because of changes to that program. That's a program a county, like most other counties, relies on heavily for improvements to public roads. Those materials also include a brief letter from Dan Zerner. Dan has a great deal of experience in community development activities all over the state, and he, in that letter, outlines for the Commission what developers are looking for in order to promote development in a county, as well as, and not just in a TIF area, but in the county generally, what sorts of things they're looking for. We also have included in that package information provided by the county engineer regarding the current status of roads and bridges throughout the county. A county police and fire study that was initiated through the Redevelopment Commission several months ago, and Baker Tilly's comprehensive plan for the county, which provides a detailed overview of the county's financial situation. Those documents are all being submitted in order to document the county's needs in those areas, and these documents could be incorporated into a modified resolution by the Commission. A number of people have expressed the desire that their property not be included in the economic development area. As you may recall, the former economic development area proposed boundaries were kind of a rectangle that included the potential solar development. We have looked at those maps and have prepared some maps for consideration by the Commission that would exclude from the economic development area any parcels that are not included in the Invenergy Trade Post project. That is the project which is nearly constructed at this point and was the impetus initially for establishing this TIF area. There's one parcel that was actually listed by Invenergy and Trade Post in their abatement application that we've since learned was not, it is not being developed, so we also took that parcel out. So it doesn't even actually include all of the abated Trade Post Invenergy properties. But all of the only properties included in the new map, which will be up for consideration by the Redevelopment Commission, are properties that are part of the Trade Post Invenergy project. Now, at this point, I hope that that resolution or those amendments, modifications of that resolution, have not been adopted, have not been considered by the Commission, but we have prepared for their consideration a modification of the original plan that includes all of those changes. So with that, we can proceed with public comment. Hopefully that will alleviate a lot of the fears people had about the former proposed plan. Thanks.
Who wants to be first?
I'll be first.
If you would, come up here, please, and state your name.
Hi, everyone. My name is Amy Lambert. And I read in the paper that this meeting was tonight. And in the article in the paper, it said that copies of the plan would be available at the auditor's office. I went to the auditor's office twice this week. Both times, nothing was available. Now, it's an exact copy of what the the thing read before in the paper, so it wasn't changed. So I just wanna know if, after you review the modifications, before you vote on it finally, if it's going to be available in the auditor's office as it said it would be in the paper for us to review. Thank you.
And when do we have to make a decision on this, Lee, in order for it to be completed? So we're good on time.
Well, it's my understanding that a copy
That's
of
a
the
problem.
existing originally approved plan is in the auditor's office. That was just confirmed today. The proposed amendments to the plan are not there because they haven't been approved. None of that has been acted on by the Redevelopment Commission. They cannot act on anything until such time as they take a vote. So it would be premature to, and the plan that is there is the plan that was adopted initially. And the process, as you may recall from the last meeting, is Redevelopment adopts the plan, has it approved by the council and the commissioners, submits the notice for publication, and at that point files the plan with the auditor's office so that that is available for public inspection. So.
Come on up front and tell us your name.
I'm Bobby Kincaid. I guess my question is, I didn't hear anything being mentioned about taking every term of blighted and underutilized out of the resolution. I don't like that being in the resolution. Those are, hang on a minute, those are keywords that are used to describe a redevelopment area or an area needing redeveloped, not an economic development area. Two different things. And so, I guess from my point of view, do we have a poorly written resolution, or do we have a resolution being put in place that has motives for other things?
And I'll go ahead and address that, Bobby. It's a phrase and a term that the state wants to see in these resolutions.
For a redevelopment,
For redevelopment.
not for an economic development.
Do you have any bridges in your area that are bad?
Yeah, probably we
Do you
do.
have any that say 9 ton or less? Any that say 15 ton?
That has nothing to do
or less?
with calling a parcel of active agricultural land as blighted.
Yes.
Okay.
But we have blighted bridges, and we have insufficient bridges in that area. From 500 north to the county line, there's at least 12 bridges that are less than adequate for the type of traffic that's on. They have a rating that's insufficient.
In addition, if the area is amended as proposed, well, first of all, it does not say that every property in the area is blighted.
It said
And
within the boundary of the economic development.
there are blighted properties within the area. But moreover, if the commission were to exclude all the parcels except the parcels that are part of the, every time I try to say it, I forget it. Yeah, Invenergy Trade Post area.
Okay.
There are no other parcels that are subject to this
Right,
resolution.
but you haven't voted on that yet.
That's correct. But if that is approved, then there is no, it seems to me there is no concern about that.
Right.
Okay.
Yes, sir, come on up front and tell us your name.
Yes, my name's Barry Johnson, parcel owner, in the original EPA. I've had a few folks reach out to me and express interest on being excluded. I've got 3, 4 of them right here. Can I submit those here tonight to be part of it, even though you're considering?
Yes, you
Gonna
can
do
submit
that.
remonstrances, yes.
Okay.
Are those in addition to the ones that you're?
I see, these are on the Excel file, these are signatory documents,
Okay.
with individual signatures. So they basically back up what was submitted on the Excel file.
Okay.
The next question.
We received a batch from the auditor, well,
Yeah.
3 or 4 batches from the auditor
Yeah.
over the last 3 or 4 days.
So there's some there.
Okay.
The next question is, so we make the modifications, and you're saying that the EDA will be restricted to that parcel with the solar companies, correct?
Well, there's more than one, but the parcels.
Those parcels that are
Parcels on
involved.
which the Invenergy project is located.
Okay, now there's 2 or 3 energy companies involved here. Is it just that one?
Just Invenergy / Trade Post.
Invenergy / Trade Post. When those, this new map gets adopted, will it be in a public hearing like this? Will that new map be adopted in a public hearing like this? Or is that something that happens and you just announce it was a change?
It would have to be adopted at a public meeting.
Okay,
It could be adopted tonight. This is a
Okay.
public meeting.
okay. So that was my 2 main questions. Appreciate it.
Yep.
Anyone else? Yes, sir.
Kyle Walker's parcel owner, and I think I'm just.
Kyle Volkers?
Kyle Volkers.
Okay.
Just following up on Barry's comment, so after this reimagined map is accepted, is it basically the same as the allocation area that you were talking about at the last meeting? Is there a difference between the allocation area and this new EDA?
The allocation area that was under consideration originally included parcels that were not in the Invenergy Trade Post area. They were in the, Maple Creek Energy, I'm sorry. Names are horrible for me. The Maple Creek area. Those parcels have been removed. The area also would include roads which connect those, roads only, public roads, which connect those parcels.
Okay, and so the only parcels in this new economic development area map that's being proposed are ones that are affected by solar panels or the companies that own them.
Well, the Invenergy, I mean, you got
Right,
yeah.
yeah.
So I can't even keep
Right.
mulling my head, so Deanna has to keep reminding me that just the Invenergy Trade Post project.
Okay, so no usable farmland parcels and no homestead parcels are being included in the CDA.
Well, I assume some of the Invenergy parcels are farm property, but they're gonna be converted, if they haven't already, to solar parcels. In other words, if Invenergy's doing something with them, then Invenergy's doing something with them and they're affected. But otherwise, no.
All right, thank you.
Anyone else?
Real quick question. Are you gonna leave in the resolution that it can be changed or modified at any time?
The statute requires the process that in order to modify it, you have to follow the same process you do to approve it in the first place. You have to have a resolution adopted by the Redevelopment Commission. That needs to go to the county council and the county commissioners. You then have to publish a notice and conduct a public hearing to amend it. There are additional requirements if you're expanding the area, that notices be sent to property owners in the existing area. That's a little bit of a wrinkle from the normal process. There's another step that has to be taken to amend an area to expand it.
So if you have a parcel that borders the EDA they have to send you a letter, is that what you're saying? I'm just not clear, I guess.
Now,
If it's enlarged,
Yes,
the enlargement area would have to be notified.
okay, by letter, not just legal notice.
If you have questions.
My name is Brooke Cutshall. I don't know if, okay, so my clarification that I have is, so all these parcel numbers that have been requested to be removed from the economic development area as it was previously proposed, does that mean then that that map will be redrawn for those excluded?
It means that they really don't matter now, because the only ones that will be in it are in the energy trade post project.
Okay, so do we
any-
get,
Anything outside of that will not be included.
okay, so do we get to see tonight the new proposed map?
If it's voted on.
If it's voted on, we get to see it, okay. And then also, would that then be available at a future date at the auditor's office or something? Okay. Thank you.
What was your last name, please?
Cutshaw, Cutsshall.
Anyone else?
Can I just clarify, sorry, one more time? So tonight you're going to vote to change the map,
Correct.
but then to finalize it, another vote has to take place at a different public hearing, or it can all go through tonight?
It could all go through tonight, but we're not gonna do that. We're gonna approve the map, let you guys see it, in case we screwed up and got one of yours in there when it wasn't supposed to be.
Okay,
So, I mean, it shouldn't happen, but, I mean, we've got a complete list from Invenergy, so it should be good to go.
okay. And then after that map is posted, then if something is inadvertently included, they can file a remonstrance.
Yes.
Thank you.
But it would help if you would call and let us know ahead of time so that we can correct it. I mean, that's the formal procedure, but it shouldn't take that much of a problem. Anyone else?
I'd just like to make one more comment that, you know, with the explanation of the reasoning behind the TIF district, to keep the county, or the funds in the county, we appreciate that, I think that was a wise move. But I think that a lot of people I talked to were very upset that were included in the EDA, the original EDA, there was no way of notification outside of just a little snippet in the Sullivan Daily Times, and just word of mouth. That was a big point of contention. But with this commission trying to keep the money in the county, I think it's a wise move, and we appreciate it. Don't think everybody's here just complaining to be complaining. But when it comes to property rights, if I wanted to put up with a bunch of this crap, I'd have built a house in Vigo County, okay? So, but, when it comes to property rights, that's pretty sacred. So, we appreciate it. In the future, it'd be a good idea to at least make a phone call or two.
Well, and we've never had anyone object to this process.
But is that perhaps because they didn't know? I mean, I didn't know till I heard word of mouth. I had no idea.
We have multiple projects in place, and, I mean, there's been a lot of discussion about them, and it's mostly been positive because of the impact that we're able to make with it. I mean, I talk about the bridges, you guys know that you have to use them regardless. So, I mean, I'd like to see them get finished, and it takes about 3 years to accumulate enough money in the Cume Bridge Fund to be able to fix one bridge. And there's 12 of them up there that already are inadequate. And that could be higher by the time we get one fixed, because they don't get any newer each year. And there is several bridges up there that have been replaced.
Well, like I said, the fact that you're trying to keep the money in the county, that's appreciated, but it just felt a little kind of backdoorish, is what I'm.
Well, and I do wanna apologize for the blight, hurt feelings, because that's not the intention of this board. It's the intention of this board to try to capture the money to help improve the county. And with the things that are happening at the state level, you know, we're gonna really be suffering. And Jason's been down working with the commissioners and the council to try to figure out how we're gonna make ends meet. And your school systems are really gonna be hurting. I mean, it's gonna be tough. So,
Well, I for one appreciate you taking the time to redraw the map and restrict it to those parcels that actually have some.
and there again, by restricting this map, it's a stretch to be able to fix something that doesn't directly impact this area. I mean, we have to be able to show that you're bringing something to this solar farm to fix something. You need a better bridge on that road. And that's the reason for the expanded area, is so that those dollars could be used everywhere around there. Now, I know you're shaking your head, you don't believe that, but it's the truth. We have no intention of taking anybody's property. I'm a no zoner, I don't believe in zoning in Sullivan County. So, that's my stance on it. If there's nothing further, do I have a motion to?
Do we wanna go one at a time on that, or do we want Jason to speak first? How do you wanna do that?
As a matter of, as a matter of procedure, I mean, typically you would approve the modifications, all of them. But what I hear is you want to have an approval of the amended modified map. What I would suggest we do is we have a resolution that first, that we reconvene this public hearing for whatever date you want. And that at that meeting, you will consider the modification of the plan to include the redrawn map that we have here and other modifications.
Is that gonna be available for everybody to see before the next meeting then?
Yeah, that's what we're, but we need some, what I'm playing with is, we need some action to say, okay, we like this map, but we're not wholesale doing the modification of the other little things that we talked about, you know, taking out that one section and that sort of stuff. Adding Exhibit D, which is all the supporting material that I mentioned. And so we don't want to take action now that forecloses doing that.
I'm gonna ask for a motion to approve the map and the parcel listing that's in the map. Is that?
For inclusion in the plan to be modified at the next meeting.
Monty, you had a question?
Yeah, I was wondering, is there any restriction on the energy?
I
can't hear you.
Are there any restrictions on Invenergy, what they can do? Cause they have free to do what they want.
As far as what?
Can they, I mean, can you wake up one morning and somebody else on Invenergy, they can, I'm sure.
Yes, yes,
Does that person have to follow the rules that Invenergy do?
yes.
Whatever's in their signed agreement.
That's an
Finding,
agreement,
finding,
that's an agreement between the county and the company that those things have to be followed for them to be able to have their abatement and the road use agreement and everything that's been put in place before.
And there are bonds for, like, the road use and that sort of stuff as well, that have to be maintained.
There's a 125% decommissioning bond that we had put in place, because some of the leases said, a decommissioning bond would be put in place in the owner's name at year 15. We didn't feel that that protected the landowners enough. We asked for it to be put in place before they put a shovel in the ground to start building their solar field, and it's 125% cost. So the county and the taxpayers are covered, and that cost would be reevaluated every 5 years.
I guess while we're at it, where do we want to put the map and parcel list so people can see it? The auditor probably would appreciate it if we didn't make everybody go to her office to see
We
it.
have a big one printed out and put in the rotunda or somewhere that it's publicly accessible.
Is that it right there, where I can take a picture of my phone and?
If that's the one they adopt. That's it, there's a parcel list, and there's a description.
You ready? I'll entertain a motion to adopt the new map with the parcels that list only Invenergy for consideration at the next public hearing. I'll second that, but I'm looking for a motion. I don't know.
I would say, don't make me cross this all out. I mean, I'll make the motion that we entertain it.
We adopt this map.
Yeah, I'll make a motion that, well, let me see it.
Well,
It's the one I.
Okay, it's the
It's the one
one,
I emailed.
yeah, I don't have any problem with that. I'll make the motion that, you know, we adopt this map pending. We'll remove anything if we find something that shouldn't be in here.
it'll be a final,
Yeah.
final adoption at the next meeting.
Yeah, yeah, I'll make that motion.
I'll second it. All in favor? Aye.
When you post and make that map available, list the parcel numbers, and we can check against ours, would be helpful.
Yes, those are,
Okay.
here's what.
Yeah, Lou, if that's all you need, then I'll entertain a motion to close the public hearing.
I think you have to set a date.
Yeah,
We'll do it at our next.
reconvene the public hearing.
We'll reconvene our public hearing at the next meeting.
Okay, does it have to be published again?
Yes.
Okay. Okay, so that's December 2nd.
December 2nd will be our next meeting, and that's when we will reconvene. What did you say? December 2nd.